Good morning from the Freedom of Information and Privacy Association. I'm Patrick Farnsworth, and this is a special edition of Access and Privacy Online, bringing you an update and summary on the Senate hearings into Bill C-4, Part 4. Over the past week, senators have heard testimony from privacy regulators, civil society leaders, and academic experts. The unified presentations all warn that Part 4 weakens Canadians' privacy rights rather than strengthening them. The outliers are the parties themselves, who stand to benefit from lower standards with the personal information of Canadians. Today, we'll walk through what happened, what tools are being used to hold government accountable, and what comes next. As usual, you can find all the supporting material in our show notes. Let's dive in. We'll begin in related news to Bill C-4, not in the Senate, but in the House of Commons. Appearing on the order paper is written question Q-865, tabled by Green Party MP Elizabeth May, who represents Saanich Gulf Islands. Written questions are not question period theater. They are constitutional tools that can compel narrative explanations from government. They are time-bound, placed on the public record, and published in Hansard. As we've said before, Access to Information asks, can the public see this record? An order paper question asks, how was this decision made, who influenced it, what risks were known, and what was ignored? Used together, they transform transparency from potentially passive document release into active democratic oversight. Q-865 is part of that dual strategy, and it comes at a critical moment. If the question is not answered in 45 calendar days, the chair of the committee is required to convene a meeting within 5 sitting days. The committee may then investigate the failure of the government to respond to the written question. However, the committee is not obliged to report back to the House or to follow any specific procedure in considering the matter. We'll be tracking this as it proceeds. Now to the Senate. It is unusual for a bill's subject matter to be split between 2 Senate committees. Part 4 of Bill C-4, Amendments to the Canada Elections Act, is being studied by the Standing Senate Committee on Legal and Constitutional Affairs, even though the overall bill is a finance measure that began in the Finance Committee. That bifurcation alone signals that something here does not sit neatly within ordinary legislation. The Senate identified that amendments impacting privacy rights, electoral law, and federal provincial jurisdiction are not routine affordability measures. Stéphane Perreault, Chief Electoral Officer of Canada, told senators that the bill may create what he described as a complete code, but one with no minimum standards and no right for electors to access or correct their data. On top of that, Perreault noted that the current draft of the bill seems to create 2 policy regimes based on internal policies of the parties. He said it's not clear what the intention of Parliament is and how we are to reconcile these 2 regimes. He noted that each party would effectively write its own privacy regime. Philippe Dufresne, Privacy Commissioner of Canada, was equally direct. He recommended 3 core amendments. 1. Minimum privacy standards aligned with Canada's fair information principles. 2. Mandatory breach notification within 7 days. 3. Formal collaboration between his office, Elections Canada, and the Commissioner of Canada Elections. Without those elements, he warned, Canadians' fundamental right to privacy remains unprotected. Dufresne also noted that political parties should be subject to the same privacy standards as those set out for the public and private sectors under federal law, while adapting to the unique role that political parties play in the democratic process. Meanwhile, Michael Harvey, Information and Privacy Commissioner for British Columbia, cautioned that Part 4 could retroactively displace provincial privacy law, including BC's 22-year-old Personal Information Protection Act, creating what he described as a privacy lacuna. Harvey also said that as it stands, the amendments do not distinguish between different types of personal information, does not allow for consent to use personal information to be withdrawn, and lacks independent oversight, among other issues. Across federal and provincial regulators, the message was consistent. Minimum standards, independent oversight, and real enforcement are necessary but absent in this bill. Next, we'll discuss academics and broader civil society and individuals who brought forward their views from research and expertise. These all echoed and supported the regulators, in many cases going further. FIPA Executive Director Jason Waiwata stated plainly that Part 4 removes guardrails at a moment when global experience, from Cambridge Analytica to Canada's own foreign interference inquiries, tells us those guardrails are increasingly important. Political parties now hold data that is as strategically valuable as the funds they raise. Weakening the rules that govern that data, he argued, lowers the barrier not only for misuse, but for democratic distortion. Professor Michael Geist, Canada Research Chair in Internet and E-commerce Law at the University of Ottawa, framed the issue structurally. He told senators that Part 4 creates a three-tier privacy regime. Private sector organizations must comply with PIPEDA, the Personal Information Protection and Electronic Documents Act. Government institutions must comply with the Privacy Act. But federal political parties would operate outside both. He warned that the bill introduces a blanket statutory exemption, removes earlier proposed safeguards like breach notification and limits on data transfers, and applies retroactively to May 31st, 2000, attempting to extinguish potential complaints and investigations into past conduct. His recommendation was clear: remove the exemption, eliminate retroactivity, restore safeguards, and establish independent oversight with real enforcement powers. Professor Colin Bennett, Professor Emeritus at the University of Victoria, FIPA advisor, and one of Canada's leading scholars on voter data and democracy, challenged the bill's core claim that it creates a, quote, national, uniform, exclusive, and complete regime, telling senators it does none of these things. He highlighted that Part 4 does not incorporate Canada's 10 fair information principles, does not impose uniform standards across parties, and does not create meaningful enforcement. Instead, he described the framework as self-regulation. He also pointed to the broader campaign data ecosystem, where modern elections involve dozens of third-party analytics firms and data processors. Many of those companies are bound by privacy law, yet under Part 4, the political parties and their agents directing those data flows would not be. That inconsistency creates confusion and weakens accountability even further. And he reminded senators that data-driven campaigning carries documented democratic risks: voter manipulation, discourse fragmentation, chilling effects on participation, and the erosion of public trust. Privacy law, he argued, is not an obstacle to democracy. It is part of its infrastructure. Professor Andrew Clement, Professor Emeritus at the University of Toronto and one of the complainants in the British Columbia case, brought the lived experience of a citizen. After requesting access to his own political party data, he received only limited records. The ensuing litigation has lasted years, as major political parties resist scrutiny and deny his civil rights. He described the insertion of privacy provisions into an affordability bill as a, quote, cuckoo's egg, and argued that the sweeping retroactivity back to the year 2000 signals that the intent is not to create a robust privacy regime, but to preempt investigation. And from the democratic governance perspective, and speaking from experience with being inappropriately targeted by political campaigns, Professor Sarah Bannerman, Canada Research Chair in Communication Policy and Governance, warned that retroactively erasing provincial privacy protections would undermine both digital sovereignty and ethical democratic deliberation. Datafied campaigning, she notes, shifts elections away from collective public debate and toward individualized behavioral targeting, often without voter knowledge or consent. From the economic perspective, Jim Balsillie at the Center for Digital Rights called Part 4 a Trojan horse. He argued that it exempts political parties from privacy rules they impose on others, at the very moment when data-driven systems shape markets, public discourse, and democratic outcomes. Also appearing were Matt Hatfield, Executive Director of Open Media, Tamir Israel, Director of the Privacy, Surveillance, and Technologies Program at the Canadian Civil Liberties Association, and Elizabeth Denham, former Information and Privacy Commissioner of the United Kingdom and British Columbia. Full transcripts from the meetings will be available in the coming weeks, but you can find links to the current Senate video through our website and show notes. Across these voices, scholars, privacy experts, digital policy researchers, and civil society advocates, the theme was strikingly unified. There is broad support for a national privacy standard governing political parties. Presenters told the Senate that Part 4 does not create one. Instead, it weakens safeguards, removes oversight, introduces retroactive immunity, and places political parties in a category apart from the privacy framework that governs every other major institution in Canada. And in a moment of declining public trust, that distinction matters. Across perspectives, economic, constitutional, democratic, the theme was unified. Political parties should not sit outside Canada's privacy framework. So, what did the political parties present and say in response? They presented a unified voice as well, through their legal representatives. Their position centers on the privilege of Parliament to make and pass laws regardless of potential self-interest. That Parliament in the present has the right to define the intent of past parliaments, that the federal political parties as small, under-financed volunteer organizations can't afford the compliance cost of privacy protections or the complexity of provincial variations, and that self-regulation and self-determined policy meets the privacy and information needs of Canadians. The Senate's Legal and Constitutional Affairs Committee will now deliberate and issue recommendations, but here's the procedural nuance. Because Bill C-4 originated in the Senate Finance Committee, any amendments or recommendations from Legal and Constitutional Affairs must return to Finance before the bill is reported back to the full Senate. Only then can it proceed, or be amended, before returning to the House of Commons. In other words, this is not over yet. So let's return to why this matters and the structural issue FIPA and others have identified. Self-written rules, amendable on the fly and enforced without independent privacy and information expertise, do not constitute meaningful oversight or protection. When the entities writing out the rules creating weaker regulation are also the beneficiaries of that weaker regulation, the risk to civil rights becomes obvious. Privacy safeguards are not abstract regulatory details. They are civil and charter rights that are part of a democratic infrastructure. Foreign interference rarely requires hacking. It often relies on lawful collected domestic data, accessed by domestic actors, and exploited through influence operations. Weakening domestic information safeguards lowers the barrier for foreign interference. And that's why regulators, academics, and civil society have spoken with one voice. The Senate now faces a familiar constitutional role: sober second thought. Whether it will strengthen this legislation or allow Part 4 to proceed unchanged remains to be seen. We'll continue to monitor Q-865, related access requests, the Senate's deliberations, and the ongoing litigation in the days and weeks ahead. As always, we hope today's special update helps you stay informed about the evolving intersection of privacy, electoral law, and democratic accountability. To support this work, be sure to subscribe to FIPA News Monitoring, or consider making a donation to help keep the mics on. Our writer is Sean Fisk. Original music is by the mysterious Breakmaster Cylinder. I'm Patrick Farnsworth, your host and producer, and we'll continue bringing you updates as this develops. Stay safe and stay informed.